Well, good evening, and thanks so much for joining us for what promises to be a very special event. For those who don't know me, my name's Matthew Harding. I'm the Dean of the Melbourne Law School, and I'm delighted to welcome you all here this evening for the second ever Flos Greig Lecture in Law. Can I start by acknowledging country? Our university sits on the traditional lands of the Wurundjeri people of the Kulin Nations. Our Parkville campus at least does. And I want to acknowledge the custodianship of that land by its traditional owners for thousands and thousands of years, a custodianship that is ongoing, one that this university strives to recognise and express respect for in all that it does. I want to pay respects to the elders of the Wurundjeri people, past, present and emerging, and I want to extend a particularly warm welcome to any Aboriginal or Torres Strait Islander people who join us this evening. I'd also like to, of course, welcome our distinguished speaker, whom I'll introduce more fully in a moment. And Mick, welcome to you as well. We're very glad you're here with us as well. The choice of venue for the lecture this evening was one that was carefully made. I'm really pleased that we're here in the building that housed the Melbourne Law School for well over 100 years before the school moved to its current location south of Grattan Street. It is, of course, in this place that Flos Greig would have been studying all those years ago. Many of you in the room also would have fond memories of this building. Where we are here now, from memory, this space was the staff library, and there was some sort of lecture theatre here, I think, I can't remember. But I can assure you that the space looks a lot different and frankly a lot better now than it did back then. So let me say a few words about this lecture, which was inaugurated last year, and then I'll move on to introduce our speaker. Flos Greig was the first Australian woman to be admitted to legal practice, and of course she was a graduate of the Melbourne Law School. She was a true pioneer. Her determination to practice as a solicitor played a material role in advancing gender equality in the legal profession in our country in the early 20th century. To celebrate the achievements of Flos Greig and her important role in the history of our law school, we were delighted last year to establish the annual Flos Greig Lecture in Law. This lecture is presented in partnership with Cornwalls, and as I speak, our friends at Cornwalls enter the room, and hi guys, nice to see you. Upon graduating from the Melbourne Law School in 1903, Flos Greig undertook her articles with Frank Cornwall, later continuing her career at Cornwalls, the firm. Cornwall's involvement in this lecture series recognises Greig's important connection with that firm and, of course, the spirit she demonstrated which transformed the basis of admission to the legal profession in our country. There is a very interesting book about Flos Greig's life written by Iola Matthews, who's a relative of Flos Greig, and she's here this evening, and thank you for joining us, Iola, and Vanessa Matthews as well. So as I said, last year was the inaugural lecture. It was presented by the Lord Mayor of Melbourne, Sally Capp, and she spoke compellingly about the new wave of women in politics. This year, we're honoured to host the Honourable Marilyn Warren AC KC. So let me introduce Marilyn to you, and then I'll invite her to deliver the lecture. The Honourable Marilyn Warren AC KC has held many offices of high distinction in law in our country. She was, of course, the Chief Justice of Victoria for a number of years, the Lieutenant Governor of Victoria. She was a judge of the Supreme Court of Victoria. She was leading light of the Bar, Queen's Counsel, now King's Counsel, and a government lawyer throughout a 50-year career in the law. She had racked up over the course of her career many firsts. The first woman appointed Chief Justice of the state, the first woman to head up the commercial and corporations lists of the Supreme Court, the first woman to serve articles of clerkship in the Victorian Public Service. Recently, Marilyn published a volume called Doing Law and Justice, The Words of a Chief Justice, a collection of over 200 papers and speeches delivered during her time as a judge. And that is testament to the significant, enduring contribution that she's made to public life here in the state and in Australia generally. We were delighted to welcome her as a judge in residence in our law school in 2020-21, a uniquely difficult time to take up that role, where remotely she did engage with and mentor students and colleagues and provided a valuable working judge's perspective to academic life in our faculty. She is currently a Vice-Chancellor's Professorial Fellow at Monash University, and I want to acknowledge her association with that fine university as well, and she's a patron of the Victorian Women Lawyers Association. We are absolutely delighted, Marilyn, that you're here this evening to deliver this important lecture. This, as I say, is the second lecture in the series. We hope the series will get up and running in a way that will endure throughout the years. To those who have generously supported this series to date, thank you sincerely, because your support is helping us to realise the ambition of establishing this lecture series in perpetuity. And of course, if anybody is interested in supporting this initiative and this lecture series, there are colleagues here this evening who'd be more than happy to talk to you about that. Well, without further ado, I'll hand over to the Honourable Marilyn Warren AC KC to deliver the 2023 Flos Greig Lecture in Law. Thank you.
Well, good evening, everyone. It's wonderful to see you here, and I'm so grateful that you have come. I'm very grateful to the Dean, Professor Matthew Harding, for his warm welcome and his very kind remarks. And I embrace Professor Harding's welcome to country and acknowledgement of the First Nations peoples of the land where we gather this evening. I also acknowledge the presence this evening of the Honourable Chief Justice Debbie Mortimer, Chief Justice of the Federal Court of Australia, and also Justice Karen Emerton, President of the Victorian Court of Appeal, together with other distinguished luminaries who are present this evening. This evening, I will set the context of Flos Greig's achievements and her place in history. She was the ancestor of extraordinary women. All the women in the room this evening would acknowledge that. And these women later forged remarkable careers in the law for the benefit of the legal profession itself and for the rule of law. I will summarily describe the careers of some of those women and their individual achievements to show that Flos Greig was a true groundbreaker. Nonetheless, the pathways of women in the legal profession have always been littered with obstacles and locked doors. I will give a brief historical overview of progress, then explain how women worked collectively to change the legal profession. My intent being that we need to know where we've come from, as the historians say, to know where we are going. I will endeavour to explain how women have influenced the very practice of law. Academic research has been done on the influence of a female judiciary in focusing on judgments and the extracurricular statements and publications of women judges. I have in mind the work, for example, of Professor Hunter and former judge of the Canadian Supreme Court, Justice Catherine Lebert-Dubé. My analysis will not consider judicial practice. That is for others. By contrast, I will consider how women have managed legal practice to achieve a higher standard, which in turn impacts on the cases heard and the judgments written by the judiciary, and indeed the quality of those judgments. In conclusion, I will then address the question of what I see a few future issues to be. But let's wind back the clock. In the early 1900s, Flos Greig's time, the population of Melbourne, including its suburbs, was about 500,000. The architecture was mostly new. The exhibition buildings, the Victorian Parliament and the Supreme Court building in William Street were all, give or take, about 20 years old. Flinders Street station had not even been built. The city basked in its post-gold rush aura as marvellous Melbourne. Despite the economic crash and depression of the 1890s with the crippling drought, Melbourne firmly held its mantle as the liberal city of the south. Sir Alfred Deakin was a leader of the new Federation of Australia, and all Victorians were very proud of him. The colony of Victoria enjoyed its new status as statehood with its 5 constitutional counterparts. Women of the middle and upper classes wore a bustle, a corset and long sweeping skirts, usually topped off by a bonnet. Looking at the Tom Roberts painting of the first sitting of the High Court of Australia in 1902, we see an excellent depiction of Australian society in the Banco Court of the Supreme Court of Victoria. In the painting, the women are all upstairs in the gallery, wearing their bonnets. Downstairs, the men are everywhere, on the bench, at the bar table, in the professions seats, and in the downstairs gallery. The population is universally male. The Roberts painting encapsulated the legal profession into which a young woman from a farming area near Bendigo in Victoria would seek entry. That Banco Court was and remains where most Victorian law graduates progress to be admitted as an Australian lawyer and as an officer of the court. Before Flos Greig, that young woman, could be admitted, she needed to obtain a degree in law. It had long been thought that women should be educated, the philosophy being, educate a man and you educate an individual, educate a woman and you educate a family. Women ostensibly were breeders. Sir Alfred Deakin was educated in his early years at his sister's all-girls school. Later, as a father, he would ensure his daughters were properly educated, but not to university level. Yet the time Flos Greig stepped up and through the emotional barriers of doing something no one had done before, she did so when women were speaking up and pressing for equality. The women in Victoria did not have the vote. They were able to vote, if they chose to, in the federal elections. Greig was an activist and an effective and articulate advocate for the admission of women. As if gaming university entry was not enough, she had to prove herself as a scholar, achieving honours in her subjects. we might reflect on the intimidating environment she faced in this building of men, more men, and only men. Indeed, if we cast back for a moment, until 1871, women were not allowed to sit the matriculation exam for fear they may become entitled for university entry. As Chancellor of the University of Melbourne, Supreme Court Judge Sir Redmond Barry permitted the ongoing exclusion of women for some time. He said, "With respect to business, especially if it be law business, I seek the intervention of a man trained to do the work." It remained the position that under Victorian law, only women could be admitted to practice. Greig's admission required passage of legislation. Earlier attempts failed. The all-male parliamentarians would not accept the admission of women. Greig's eventual admission required the passage of the Legal Profession Practice Act 1903, colloquially known as the Flos Greig Act. The historical act of her admission passed without comment in the minutes of the Board of Examiners, which simply certified her readiness for admission. Interestingly, the Act provided in Section 2, quote, "No person shall by reason of sex be deemed to be under any disability for admission to practice as a barrister and solicitor of the Supreme Court of Victoria, any law or usage to the contrary notwithstanding." If we reflect where we are now, of itself, that Act over 120 years ago was an early codification of human rights and sex discrimination laws. Upon Greig's admission, my predecessor, Chief Justice Madden, said, "Miss Greig, allow me to express my gratification at the graceful incoming of a revolution and to express a hope that success which has attended you as a student may indeed attend you also in your career as a barrister and solicitor." Then came the warning. "I also trust the profession, the noble profession, of which you are the first female member in this country, will be well preserved and sustained in your hands, as it has heretofore been in the hands of the other sex." To which I interpolate, no pressure. However, Chief Justice Madden made public statements to the contrary in the main Melbourne newspaper, expressing reservation and caution about letting women into the legal profession. After her graduation and admission, there was no flood of women to follow Flos Greig. In the 20 years after her admission, only 34 women were admitted, compared with over 1,000 men. It was not until 1939 that yearly admissions of women hit double figures when 12 women were admitted. It took until 1997, almost a century, for the admission of women to exceed those of men for the first time, when the split in Victoria was 388 women to 334 men. One of my roles when I was Chief Justice was to preside usually over the admission ceremonies of new lawyers in the Banco Court. In my time, we calculated I presided over the admission of something around 15,000 lawyers. Over that time, it was a very plain phenomenon that women were in numbers of 60% or more. But we will talk about that more in a moment. Between 1903 and the end of the 20th century, progress for women was slow in the law. But there were some lights on the hill. In 1916, more than a decade after Greig, Lesbia Harford graduated in law and later became the first woman to sign the bar roll. However, her extracurricular interests worked against her with her public bisexuality, political campaigning against social injustices, and the publishing of poetry. She was doubtless seen as an aberration and probably evidence of what happens when you let women in. Later, Joan Rosenau was admitted in 1919. She was a powerful presence as a prominent barrister in the criminal and matrimonial practices. When not robed, she wore a full-length mink coat, a fascinator, and smoked through a long cigarette holder. She wore that outfit around her chambers. But Rosenau was not taken seriously in important quarters. Another of my predecessors, Chief Justice Herring, refused for 11 years to appoint Rosenau as Silk, a Queen's Counsel. Fortunately, one of the early acts of another of my predecessors, Sir Henry Winnicky, was to appoint Rosenau Silk in 1965, the first Victorian woman Silk. Bar chambers in Melbourne proudly bear the name Rosenau. Little progress was made in the law until the 1960s and 1970s, when women were starting to be seen in the profession, but they were mostly sent off to practicing conveyancing and family law. Yet the feminist movement of the 60s and 70s slowly permeated Australian and Victorian society, and in time, inevitably, the legal profession. In the early 1970s, a woman could then be denied a legal job because she was a woman, as happened to me. It took a later decade of equal opportunity and sex discrimination laws to prohibit that behaviour. In that era, there were female presences occurring. Marcia Neave featured in the Daily Melbourne Press because she won the Supreme Court Prize at the University of Melbourne. Notable because Neave became engaged to marry her fiancé on the same day. Neave would proceed to forge extraordinary pathways in the law as a scholar, law professor, law dean, law reformer, jurist and royal commissioner. As an academic, she co-authored the primary law text on property, Sackville and Neave. As advisor to government, Neave achieved the decriminalisation of prostitution in Victoria. As a law reform commissioner, she effected change in a range of areas, from the law of evidence in sexual assault trials to the practice and rules of civil procedure in litigation. Later, after a decade on the bench, Neave chaired 2 state royal commissions into family violence. In the academic world, women moved beyond a sprinkled presence in the law to the first woman law professor at the University of Melbourne, Cheryl Saunders. Now laureate and professor emeritus, she became heavily involved in the teaching and development of constitutional law nationally and internationally. In the 1980s and 1990s, whenever an event occurred in constitutional development of law reform, state or federal or international, Saunders was present as an academic leader and government advisor. There were numbers of other leading women, including those who gave up their successful legal practices to accept judicial appointment or high office. The drivers for such change came from attorneys general who embraced the changing, more feminised era and understood the essence of the vision of a woman on the bench. The first female Victorian Attorney General, Jan Wade, appointed 3 women to the Supreme Court of Victoria between 1996 and 98, including the first woman, Rosemary Bamford, in 1996. As a first-hand witness, I can say it was breathtaking to see a woman sitting on the bench in the Banco Court. Bamford, incidentally, along the way, had won the Supreme Court Prize at the University of Melbourne. Sir Darrell Dawson, later a Justice of the High Court of Australia, was second. And Rosemary did that after being told when she was a student, "Law? That's a funny course for a woman." Incidentally, each of the women I have described were also mothers. They juggled their pregnancies, child raising and childcare arrangements with their extraordinary careers. Each of these women excelled in the law as jurists, scholars, and law reformers by virtue of their individual intellect, intelligence, cleverness, performance, and work ethic. Individually, their achievements changed the development and application of constitutional law, women's human rights, family violence laws, and more. They were exemplars. They were the lights on the hill for surrounding women and the next generation. Women lawyers and law students could look to those women and see themselves. However, despite those exemplars, and there were many more, by the 1990s and early 2000s, the legal profession had in fact changed very little. Despite the majority of law graduates being women, men remained in the driving seat. Sitting as the judge in charge of the commercial list of the Supreme Court of Victoria in about the year 2000, I would enter the courtroom on direction days and see a sea of men in suits. On most trial sitting days, the only women in the courtroom were my associate and me. So rare was the appearance of a female barrister that I started to keep a list of when one appeared, noting usually the appearance was in a junior non-speaking role. Reverting back to the expansion of equal opportunity and sex discrimination laws, women lawyers were struck by the prevailing inequity of legal practice. Plainly, the individual achievements of outstanding women, a few I have mentioned, did not have much reformative effect on the profession itself. Individual achievement, no matter how glorious, did not penetrate. In my experience, there was a prevailing attitude of, well, she's exceptional, or, well, she's preoccupied with motherhood now. The realisation occurred that individual achievement was not enough, no matter how brilliant it was. Collective action was a necessary strategy to move the unmovable. In the mid-1990s, there was movement nationally to establish a national representative body of women lawyers. Victorian women tapped into that movement. A seminar chaired by my immediate predecessor, Chief Justice John Phillips, was attended by hundreds of women lawyers. The concern was that notwithstanding the numbers of female law graduates, there was a disproportionately high attrition rate of women from the profession. On 19 August 1996, Victorian Women Lawyers was launched by the then Victorian Attorney General Jan Wade and Eve Marlap, who delivered the keynote address. VWL was incorporated under the Associations Incorporations Act. Its objects include to provide a common meeting ground for women lawyers, to foster the continuing education and development of women into the legal profession and their advancement within the legal profession, to encourage and provide for the entry of women into the legal profession and their advancement within the legal profession, to promote the understanding and support of women's legal and human rights. In 2001, VWL published a watershed document, Flexible Partnership, Making It Work in Law Firms. The document was co-sponsored by the Law Institute of Victoria and law firms Mallison Stephen Jakes, Freehills, Deakins, Blake Dawson Waldron, Maddox, Minter Allison, Allens, Arthur Robinson and Middletons. Most of those firms continue to exist following mergers and various iterations. The VWL document was steered by a work practices committee made up of VWL women. The authors were Sue Kaufman and Georgina Frost. Both were VWL women. The crux of the problem addressed was the need for flexible work practices in the legal profession. Kaufman noted, "It is clear that the stress and attrition observed at staff level in private law firms are part of a long-term and profession-wide trend. Secondly, women lawyers are clustered at the entry and associate levels and are generally leaving law firms without becoming partners. The VWL report listed the perceived inhibitors. They included disgruntled clients that perceived lower service levels from absentee women lawyers, perceived lack of commitment by the woman lawyer to the firm, resentment at female partners sharing in firm capital without an equal distribution, disgruntled colleagues at the female absence, alleged underutilisation of resources, reluctance to provide part-time arrangements, and lack of female role models. The VWL recommended the establishment of guidelines and policies to establish an equitable open process for setting up a flexible work arrangement, including balancing the interests of the firm partnership and the female partner, transparency with clients and colleagues, proper management and assessment of arrangements, part-time partnership to be treated as permanent, an improvement of female role models by increasing the number of female partners. Following the report's publication, the VWL convener informed me that there had been a vigorous debate with the 13 managing partners of medium-sized firms, and support was given in principle. VWL marched onwards, and indeed it was a watershed document. It produced a set of guidelines based on sound evidence that had never existed here in Victoria before. The Law Institute of Victoria, as the primary and largest professional representative body, sponsored discussions. In my mind, there were three imperatives that came into play. First, the determined collective action of VWL as an association representing women lawyers. Second, the support of the main professional representative body of Victoria, the Victorian lawyers, the Law Institute. And thirdly, a significantly committed male champion of change at the time, John Cain, the then Executive Director of the LIV. Relevantly, at this time, VWL accrued modest income through membership subscriptions and sponsorship. It sought charitable status, which was rejected by the Commissioner for Taxation. The decision was challenged by VWL. The Commissioner argued that if the main objects of an institution were the protection and advancement of persons practising in a particular profession, the institution would not be regarded as charitable because the elements of direct public benefit was lacking. VWL was determined. It challenged the Commission's ruling in the Federal Court. Justice French, as he then was, allowed the appeal, stating, VWL was established to overcome a well-known social deficit, namely the substantial underrepresentation of women in the legal profession, in its upper reaches and the judiciary. Having regard to the social norms reflected in the Sex Discrimination Act, cognate state legislation, and Australia's membership of the Convention for the Elimination of All Forms of Discrimination Against Women, that objective was a purpose beneficial to the community. It was within the spirit and intendment of the Statute of Elizabeth. VWL 1. Looking back at the Commissioner's rejection, it is puzzling that supporting and promoting women was not viewed from the beginning as beneficial to the community. VWL continues to this day. It is extraordinary in its reach, power, influence and representation. It has committees on publications, justice, law reform, public sector lawyers, networking, outreach, work practices and diversity and inclusion. VWL mentors law students as well as practising lawyers. It aims to make women lawyers more competent, confident and articulate through substantial mooting competitions. Finally, It publishes a legal feminist publication annually entitled, appropriately, Portia. I encourage its reading. Parallel with the VWL, the Victorian women barristers faced a different struggle. In the 1990s, the Victorian Bar sponsored a survey and report into the treatment of women barristers entitled Equality of Opportunity for Women at the Victorian Bar. In summary, it disclosed rampant discrimination against women barristers by male barristers, judges, magistrates and clients. My experience had been, as a barrister, that I could have a brief taken away from me because I was a woman. The report was promoted by the Women Barristers Association, led then by Rachel Lewitton. In 2002, a woman barrister, Fiona McLeod, led the Victorian Bar to implement the model briefing policy to conduct a further work, the Equality of Opportunity for Women at the Victorian Bar report. It made recommendations including, and these are very interesting because they sit alongside what I told you about a moment ago with the Victorian women lawyers. The recommendations with respect to barristers were that senior barristers ensure a balanced gender mix in chambers allocation. It couldn't be all blokes anymore. Bar social events to be held in a welcoming atmosphere and never at male-only clubs. The Bar was recommended to organise education on sexual harassment, representation of women on the Bar Council and committees. Again, it could not be all men. There was recommendation of recognition that the Women Barristers Association has a valuable role, not just for women, but for all barristers. Sexist behaviour was recommended to be combated. There was encouragement for government agencies and private firms to utilise gender balance in briefing practices and to pursue it as a key performance indicator. It was recommended that there be change initiated in the attitude towards pregnant barristers and those who were mothers, and the accommodation of childcare arrangements with sympathy and understanding. Finally, there was a recommendation of gender awareness education for judges. I'm pleased to say that in my role as Chief Justice and Chair of the Judicial College of Victoria, that was one recommendation taken to heart. By 2013, the Law Council of Australia had been brought into the picture because reports of discrimination were presenting nationally. The Council commissioned the National Attrition and Re-engagement Study. Importantly, it was the Victorian report which was the genesis of the national report. Not waiting for the national movement, the Victorian Bar introduced its discussion paper, Making the Quantum Leap, in 2014. Again, one of the leaders of the paper was Fiona McLeod, by then Fiona McLeod SC. The paper acted as a barometer of the Victorian Bar with the following aims: for the recording of data and providing basic metrics to develop and progress women barristers, to improve the income and experience of women juniors by encouraging the briefing of women in significant cases, the elimination of unconscious bias by exposing briefing authorities to the skills of women barristers, responding adequately to the discrimination and harassment of women barristers, addressing the gap in earnings between male and female barristers, engaging with women during a career break to encourage return to practice, to conduct exit surveys of departing barristers to resolve female attrition rates, and there was more. The Victorian Bar's Senior Counsel were asked to give what was known as Silk's undertaking. The signed undertaking included this statement: at a minimum, I commit at least one new woman barrister working in my area of practice each year on a research task and, if suitable, recommending them for a junior brief. There was more. There were unconscious bias continuing professional development sessions. The Victorian Bar's conduct rules were amended to expressly prohibit discrimination, sexual harassment, as defined under state and federal legislation, and workplace bullying. These reforms were gradually implemented over time, supported often by the presence of women on the bench. As more women judges and barristers were appointed, they in turn supported and encouraged women barristers. Women judges did and still do like to see female barristers appearing in court. The Bar's work led to consultation with the judiciary. Many heads of jurisdiction, including the superior courts, led and spoke at seminars involving the large law firms and the briefing authorities of the state and federal and government and regulatory agencies. For example, at seminars co-hosted by Justice Michelle Gordon of the High Court of Australia and Kate Jenkins, then Federal Sex Discrimination Commissioner, the question was asked at small roundtable working discussions, and when did you last brief a woman barrister? And in what type of matter? Alarmingly, there was a too regular response of, I cannot recall. That is a difficult response to give to Justice Gordon and heads such as myself. At the follow-up seminar, when the question was asked again, there was a commendable change. It seemed the walls of the Victorian legal profession were cracking. VWL was effecting change to give women flexible working practices. A feminine presence in law firm partnerships slowly appeared. Women even became managing partners, including at a national level. Commensurately, major corporations had powerful women chairs and CEOs who applied equal opportunity policies and expected that the best lawyers and barristers would include women. Governments, state and federal, applied equality principles for their lucrative and expanding legal work. The female presence on the court benches and in significant seats was expanding. There were women as heads of jurisdiction, as solicitors general, as Crown Counsel, as lead counsel assisting royal commissions and inquiries. Indeed, the Victorian government since 2014 has had a public policy that 50% of all judicial appointments will be female. As an aside, one of the best promoters of women as lawyers has come from technology. The streaming of royal commissions, from Black Saturday Royal Commission to that for banking to that for robo-debt, has encouraged a broader public curiosity in how hearings work, accompanied by a revelation that women lawyers are clever, competent, articulate, assertive, and controlling. The legal landscape has changed because all lawyers and their clients, current and potential, have seen that when it comes to business, especially if it be law business, often the best man for the case is a woman. In my firm view, female members operating individually were not enough to change the legal profession. It took the collective action of women together to progress equality as pursued and achieved so far by the VWL and the WBA, together with their interstate and national counterparts. Whenever there was a first female appointment, albeit as a partner, Chief Justice or Solicitor General, there was always such a fuss. These days, I venture to suggest the novelty has mostly evaporated. But to complete the picture of women's influence on the legal profession, I need to turn to what I will call the dark side. Over the decades, as the reviews and reforms were developed and implemented, female dissatisfaction and attrition in the legal profession continued. In 2012, the Victorian Equal Opportunity and Human Rights Commission, HERIOC, in its report Changing the Rules, looked at the experiences of female lawyers in Victoria. Heriock made these findings from its surveyed respondents. 40% had personally experienced discrimination while working as a lawyer or as a trainee. The discrimination encompassed hostile work environments, workplace bullying, unfair work allocation, and unequal remuneration. 70% of those discriminated against were working in private firms at the time. 6 out of 10 of the women who experienced discrimination did not make a complaint. 23% experienced sexual harassment, with 63% of those incidents occurring within the first 12 months of being in a workplace, in other words, a new or junior lawyer. In 3/4 of those harassment cases, the harasser was in a senior or supervising position, and 2/3 of those harassed did not make a complaint. The Heriock report made recommendations to stem the problems. However, the report did not receive the prominence it deserved. Its findings were truly alarming, coming as they did. Yet that was not the last of it. While VWL with the Law Institute and the WBA worked through their reforms and policies, the nation was not shocked by the discrimination revealed. There seemed to be a social acceptance, including in the legal profession, of, well, it happens. Sexual discrimination laws had been in place for decades. The Commonwealth Sex Discrimination Act commenced in 1984. So to reiterate, sexual harassment in the workplace had been unlawful for decades. Despite the revelations of the Women Barristers Association and Heriock, society believed, and I have to confess, including myself, that women were safe with judges. Yet in the highest court in both the state and the country, women lawyers working as a judge's associate, in multiple instances we at least know of, were sexually harassed. The revelations were shocking and shameful. In my own case, I thought I presided over a collegial and safe workplace where associates flourished and progressed their legal careers. The multiple cases in the High Court of Australia and the Supreme Court of Victoria possibly came to light because of the Me Too movement. However the evidence came to light, it remains that the women affected suffered the impact privately for a long time. They courageously came forward and made their complaints. The cases warn all women that there has been a dark side to the legal profession, even in the courts, where women lawyers can be the victim. These cases revolve around power and consent. I encourage all women lawyers to read the pamphlet publication Power and Consent by Rachel Doyle SC. Indeed, I would like to see the publication as mandatory reading for all lawyers at all levels. Suffice to say, when Flos Greig was admitted to the legal profession, sexual harassment may in all likelihood not have troubled her. I truly hope so. But in the century since, sexual harassment and discrimination has been a burden women lawyers have faced. I fear it has not gone yet. I am certain women will continue to be a forceful and persuasive presence within the legal profession. Notwithstanding the challenges, there are ways to convert those challenges into opportunities. First, let me suggest the working from home phenomenon. Some time away from the workplace with flexibility is productive and constructive. For many women, especially with family responsibilities, it is a pressure relief valve. Yet women lawyers must be alert to the risk of being sidelined or their advocacy diluted. If they are missing from the meeting or trying to engage with a meeting through a Zoom presence, it may be quite counterproductive for what women need to achieve. In my view, the physical presence is essential to most legal institutions. We must remember too, on a more humorous note, the American lawyer who appeared in court remotely but as a cat, his daughter having earlier been communicating in character with friends. Secondly, an opportunity may arise with artificial intelligence. It is a boon to the busy lawyer, yet it brings risks of human minimisation, redundancy and irrelevance. My instincts tell me that women lawyers could be the first to be dispensable. We should be mindful of Justice Mary Gaudron's judgment in the Bakovic case, where the women were the most recent to join the workforce, and when retrenchments occurred, the union applied the policy of last on, first off. However, as women had only recently joined the workforce under equality of opportunity policies, they were discriminated against by virtue of their gender. The third point I make, sexual harassment will continue as long as society has opposite sexes. It is a serious issue society faces, one of the issues of the time. Women lawyers must be ever vigilant and protective, not only of themselves but of each other. If sexual harassment occurs, I urge women lawyers to disclose it. As lawyers, I urge them to prosecute tortious actions under occupational health and safety laws. An order of damages has a sobering effect on the predatory offender, together with the deterrent effect of public disclosure and shame. Fourthly, I urge consideration of the policy framework which can support and enable women. It is worthy of close examination and deep reflection. Taking the equality of opportunity and sex discrimination statutes as a base, women are supported through the United Nations Environment, Social and Governance Sustainable Development Goals. Gender equality is one of those goals. It is therefore, I suggest, a legitimate inquiry to ask any employer as to what the ESG compliance and SDG application arrangements are of the employment place. Corporate and institutional clients are bound, or at least encouraged, to demonstrate their performance under social governance arrangements. As an extension of ESG, employers should have gender equality action plans which cover recruitment, career progression, promotion and development, gender composition at all levels of the institution, appropriate gendered work segregation, workplace support, leave and work flexibility, workplace culture, leadership and diversity, and gender pay equity. The risk is, unless there is a gender equity policy, it is easy for things to slip back. In other words, the risk will be of, we had a woman here, we used to have a female partner, but she left, not sure why, or she's off having babies. A trap can occur such that the modern hard-fought new norm of women being prominent in the law dissipates, even disappears. 20 years ago, I urged women lawyers to keep gender on the agenda. I have said it repeatedly. Sometimes in the busy public discourse, gender can be forgotten and sidelined. As one half of the Australian population and as the majority gender of Australian lawyers, it is essential that women occupy at least half of the seats at the table. A last set of observations. The Australian taxpayer subsidises to an extent our universities. Surely, as women form the majority in law graduates, the taxpayer should be able to yield a dividend. Society itself is constituted around 50% by women. When only part of that half of society goes to court or engages with the law, that female half should be able to see itself reflected in the practice of the law. Why? because it cannot be that the best intellectual ability lies exclusively within the other half of society. The rule of law underpins our democratic society. The rule of law must ensure equity and justice, fundamental tenets. It is the legal profession that underpins the rule of law. It behoves the profession to demonstrate gender equity and justice within itself so that those tenets flourish under the rule of law. Thank you.
So I'm just going to invite Marilyn to take a seat, and there'll be time for a few questions. So if you'd like to raise your hand and then let us know who you are and make your question as brief as you can, that would be great. Yes, thank you.
What would you say to women in the profession who are the victims of sexual harassment or poor treatment, who are afraid to come forward and put themselves in a position of troublemaker, those sorts of the issues, the kind of thing that those poor associates must have been terrified of all of those years?
Well, thank you very much, Liz, for that question. It will vary from institution to institution, but those who are the heads of institutions, whether it is a court, the president of the bar, the dean of a law school, needs to be constantly vigilant as to what is going on. I gave the example in my case where I trusted judges. I thought I knew what was going on. I thought I had very, very good intelligence and sources, but the problem possibly was, despite all that, there was that intimidation, that fear and embarrassment of coming forward. So it is critical that there be human resources within an institution that that women can go to privately and confidentially and feel supported. Despite my urging and whatever else may occur, there may be individuals who do not wish to formally lodge a complaint. What they would prefer to do is to feel safe and be relocated. If I had known of what occurred in the particular instance I referred to, I would like to think that I could have taken steps to make those individuals feel safe. It is about safety, and that is what we must do. But we can never take for granted, we can never be smug that our institution is a safe collegiate place to work. That was very much the lesson that I learned. And for those in the room who are heads of institutions, I really do urge you to be vigilant and constantly monitoring in appropriate ways as to what is happening.
Thank you. Any other questions? Yes, thanks.
Hi, I'm Jeannie Patterson and I'm from the Law School at Melbourne. My question is this. Earlier this year, I think it was this year, Lord Sumption came to Australia and was asked about the representation of women on the Supreme Court in the UK and said that, well, of course, it would be good to have women. I'm paraphrasing, I apologise. It would be good to have women, but you know, promotion to the court was a matter of quality and expertise, and there just weren't women with the expertise and quality skills that were needed for the court. I just wondered your view on overcoming that quality, expertise, specific skills argument.
Thank you, Jeannie. That's England, and it truly is. They do have a lot of problems compared with us with their appointment process, notwithstanding what they've tried. And I've spoken to women who have been appointed to the Supreme Court of the UK, and I've spoken to women who missed out on being appointed to that court. And it's not a happy place, and it's difficult, and in my view, from what I've heard, it doesn't work well. what Mr. Sumption said is quite frankly a load of absolute nonsense, and I'd like to have had the opportunity to have spoken to him myself, because I can point to any number of women in this room of outstanding intellect who'd be able to match it with any male in the country or indeed anybody in England. That's a cultural class problem in England. But here in Australia, that just doesn't wash anymore. And I don't want to embarrass some of the women present in the room. But I can tell you one story. I was speaking a couple of months ago to a stockbroker, and he was quite a young man, and he didn't know anything about the courts or the law, but something came up about what happens in the law, and he said to me, "Gee, that Orr woman, she's amazing." And what had happened was he was a non-lawyer who had watched the stream service for the Banking Royal Commission and saw this woman who was extraordinarily powerful, articulate and competent. And it turned out the performance of now Solicitor General for the state of Victoria was renowned across what I'll call the masculine business sector and finance sector, because there was this woman they were all in fear of, because she was so good at her job. Hence I made the point I did. But quite frankly, Jonathan Sumption, well, you know, when I see him, if I see him, I'll speak appropriately.
Now, I know there are two more questions, one here and then at the front, and then we might proceed from there.
My name's Anne Genovese. I'm also on faculty at Melbourne Law School. I want to thank you for your excellent words and your excellent advice, which I think thinking collectively is always much more productive than thinking of ourselves as individuals in any form of advocacy or contest in the workplace. So obviously the demands of people's lives make collective activity very difficult. So I was wondering if you had any advice on that point, how to join together to continue the sort of collective action that you're talking about.
Well, the conveners of two outstanding organisations, the VWL and the WBA, are here this evening, so start by talking to those organisations and become active in their processes. Whilst the Barristers Association is concerned with barristers, VWL has a very broad and welcoming membership base, so that's a good starting point, including for the students who are present this evening. But you can do things locally on a village basis within your workplace. You can do it within a faculty, within a set of chambers, within a law firm. Within the law school for the students where you are working. And again, I do see that there's a responsibility for women at what I'll call the mid-tier level and then the more senior level to actively engage and perhaps encourage and facilitate, so that there are fora where women can come together. And I would also encourage that it not always be to the exclusion of men. Men are not the enemy, they're the partner, and so much the better if men can be involved.
Thank you. One question here.
Thank you, Your Honour. And I'm Sophie, I'm the President of VWL currently, and there's a few former presidents in the room, and we're very grateful to have you as our patron. I did just want to ask a question and actually perhaps also ask Professor Harding for his views on this. I agree that we need to bring men on the journey, but I'm always disheartened when we have events like this and the room is filled with women and men don't want to turn up. So does Your Honour have any suggestions on how we get the men in the room and be part of the conversation?
Well, it depends. If I go back to my time on the court, the former President of the Court of Appeal, Justice Chris Maxwell, was a great supporter of women. And I would only have to speak to him and say, give it some support or come along, and he'd be there and he'd go along and bring colleagues as well. So I would encourage, Sophie, that they actually be invited. And the same with Liz Ruddle, convener of the WBA. Invite them, encourage them. They can find the time.
We could take one more from you.
I'm sorry, Professor
I'll add-
Harding didn't. Do you want to respond?
I have nothing to add except to say that if men like me can help to rally the troops, as it were, then always happy to do so. Yep.
We'll send you some emails.
I welcome that.
Hi, Natalie Gray's my name, and I'm a donor to the law school for scholarship. And my sister was very active, Liz Gray, in law before she died of cancer. And I've got a query in relation to your comment about fearing people. And I query that one of the better attributes of having more women in any profession is that they can bring reason and femininity and remove the idea of pushing and pulling and fear and bring in compassion and understanding and fairness. And I'm interested in your thoughts on the value of women in removing fear from consequence and creating hope.
Thank you very much. I referred at the beginning of my remarks to Justice Catherine Leroux-Dubé of the Supreme Court of Canada. She had spoken extensively about this, and then there is an academic, Professor Rosemary Hunter, who's written extensively. So if you're interested in the topic, I do encourage you to look at their works. My experience as a judge was when I went into court, I didn't go into court consciously as a woman to deliver a feminine result in a particular case, but there must have been, no doubt, a feminine impact. So I do believe I had, in criminal matters, particular empathy with the mother of a victim who had been murdered, or a woman who had been sexually assaulted, who may have been sitting in court on an appeal, to ensure that those individuals felt that there was a good hearing, a careful listening to what the whole of the story was. And if I take, for example, sentencing is one area as a judge where you can deliver a sentence that exposes and delivers empathy. The individual family may not be satisfied by the end of the day with the sentence that is imposed, but if things are properly and carefully explained in the sentence, then that can be conveyed. In terms of fear, that operates in a range of ways in courts. In a commercial trial between commercial leviathans, there mightn't be a lot of fear except about losing their money and the efficacy of their case. There might be the nervousness of the witness. But that's quite different to the fear that pervades a criminal trial where someone's freedom is at stake, or the horrific injuries that were perpetrated against a loved one exposed in excruciating detail in the court. What I did, and I believe all of my colleagues did it, but I certainly know my female colleagues did and continue to do it, was to have a calm court place and to try as best as possible within the rigours and structures of an ancient environment for people to feel not comfortable in their lounge room sense, but comfortable and confident that justice was being delivered. So as a judge, you are acutely conscious of everything that is going on before you, and you take account of that. And when I was a barrister, I would endeavour, even when questioning, cross-examining the most difficult, unpleasant witness, to always try to do it respectfully. Sometimes when I was a judge, I can recall a couple of my criminal colleagues, when I sat on an appeal, criticised me later afterwards and told me that I was too kind to the prisoner. I didn't agree with that. I felt that the prisoner deserved to be treated with dignity. So you can get variations in views, but that was my approach to it. But thank you for your question.
Thank you, Marilyn. And thank you to those of you who've asked questions. Now, I said earlier that this lecture series is delivered in partnership with Cornwalls, so I'm delighted now to invite Bianca Kwan from Cornwalls to offer the vote of thanks.
Thanks, Matthew, and good evening, ladies and gentlemen. It's been an honour to again be part of this wonderful event, and Cornwalls is very proud to sponsor this lecture in its second year. On behalf of Cornwalls, I'd love to extend my heartfelt gratitude to our guest lecturer, the Honourable Marilyn Warren AC KC. Thank you. During my time as convener of Victorian Women Lawyers, I had the pleasure of working with Marilyn as VWL's long-standing patron, to obtain her valuable insights into the progression of women in the profession and to get her input on some of the initiatives that Marilyn mentioned in her oration tonight. She's an inspiration to me and to many women in the law, and it's been an absolute privilege to have her deliver the Flos Greig lecture this year. Tonight, Her Honour has taken us beautifully through the history of women in the law, particularly here in Victoria, through some of the significant obstacles and attitudes they faced and just how far we've come. Her Honour's insights are a reminder to acknowledge and celebrate the achievements and contributions of those who have gone before us, both the outstanding individuals who have well and truly paved the way and those organisations whose mission and purpose has been to advance the women in the law. They are also a call to action to continue that work, to be alive to the issues and challenges that women in the profession continue to face, to stand together and support each other to call out harassment and discrimination in the profession, and to be mindful of how the changing landscape of the nature of legal work and work practices may impact women in the law and the policies that firms have in place to address gender equality. Marilyn, thank you so much for your time and thought-provoking lecture. We do have a token of our thanks, so please accept these with our to Professor Matthew Harding, thank you for your continuing support of this event and your vision and commitment to honour Flos Greig. Today's lecture is timely. Just yesterday, we celebrated 118 years since Flos Greig was admitted to practice as a barrister and solicitor in the Supreme Court of Victoria, as we know, the first woman lawyer in Australia. As Marilyn spoke about earlier, women have been paving the way for the success in the legal profession, and today we acknowledge what a true trailblazer Flos was. Sincere thanks, obviously, to the University of Melbourne and the Melbourne Law School organising committees and all the volunteers who have tirelessly worked to make this event possible. We very much appreciate all the work you've put in behind the scenes to deliver this lecture flawlessly each year. To the catering staff, support crew, technical team, thank you. Couldn't do it without you. To our special guest, and I think, yes, I saw her before, Iola Matthews, the great niece of Flos Greig. We really appreciate your ongoing support and all the fantastic insights you've been able to give us about Flos's life. It's been invaluable, and we're really proud that you can join us again this year. Lastly, thank you to all of you who have joined us here tonight. Your presence here reflects the commitment to our vision to honour Flos Greig and to ensure that the future for women in law in Australia is filled with opportunity, equity and meaningful engagement. So please enjoy the dinner, and on behalf of Cornwalls, we look forward to your continuing support and seeing you again next year. Thank you.